SJC-12096, Commonwealth v. Amanda L. Hammond.
Ms. Dahlberg, good morning.
Good morning. May it please the court. I'm Nancy Dahlberg here on behalf of Amanda Hammond. And we're asking that the defendant's convictions for statutory rape be reversed for reasons that pertaining to the trial itself. But we're also asking that the court hold that the defendant has a due process right to an individualized hearing under Chapter 6, Section 178E-F to determine whether she presents any cognizable risk of reoffending before she's required to register as a sex offender. And I'd like to...
Wait, on the first, we don't reach the second, correct?
Well, in a perfect world, I would ask, ideally, the convictions are reversed, but I would still ask the court to consider this issue because it's not going to come, it's unlikely to come before the court otherwise. It's because of the language of the statute and the way it's fairly clearly written and explained in Dalton. Attorneys believe that they are foreclosed. And I would argue that under the case law promulgated by this court, there is a due process right as applied to her and to other probably defendants convicted of statutory rape. There aren't a whole lot of cases that result in probation for that. So I was going to start with that issue, if that's all right, and be sure to return to the other ones. So as I said, the defendant here met the criterion under 178E-F for consideration as to whether she represented a risk of reoffense and had to register. However, the statutory language would preclude the judge on its terms from doing that. I want to mention before I go on to apply the balancing test under Matthews v. Eldridge, which this court has used in a number of cases that are relevant, that the defendant can't get relief from the SORB classification process as the Commonwealth has argued. There is a parallel statute, 178K2D, which basically says that SORB has to classify sex offenders as level 1, 2, or 3 and not excuse them if they are guilty of a sex offense unless they've registered for 10 years. So there's parallel preclusionary language that would not allow her to be excused under the SORB process unless she had registered for 10 years.
Okay.
Did I not make that clear?
No, you made it clear. I guess I did think that there was some capacity in SORB, but I'm obviously incorrect, in this kind of case to, but it may be because involves a child? I mean,
right.
Is that
right?
Is that
there are
why?
a number of categories. It's actually very similar language. You know, one can argue that the language from EF differs from K2D in that, you know, the burden, who does the burden fall on? But those categories preclude the judge completely under EF and at least for 10 years before SORB. And so it's no solution.
No, I guess where I'm having trouble is imagine there were a mandatory sentence for statutory rape, 10 years. In this case, obviously, it would be a miscarriage of justice to have imposed that, but that's what the legislature said. Here, you can argue it's a miscarriage of justice to require registration under the circumstances of this crime, and I gather the judge probably would have agreed with you not to do it if the judge did not feel that the judge had to. But why would you get an individualized determination for this if you would not get individualized determination for a mandatory sentence? They're both losses of liberty.
Right. So under EF, an individualized, a hearing only comes up, or the judge actually is compelled to give such a hearing if he's imposed probation. So for all of the reasons that go into giving probation for a sex offense versus imposing a 10-year mandatory sentence. Now, I would think that if 10-year mandatory sentences were being imposed in cases like this, we'd be before you on that case. But in this particular situation, we're really focusing on this statute, and it only arises in situations where the judge has determined the circumstances would warrant probation. So I hope that's helpful. But to go on just to the Matthews v. Eldridge balancing test here, in this particular case, to talk about the government interest in public safety, and based on the judge's findings, he found that 3 sexually mature adolescents sought out the 22-year-old defendant, took her into the woods where a sexual encounter took place. He found that while her level of intoxication was in dispute at trial, her conduct was an aberration, the result of impaired judgment due to alcohol intoxication, use of Percocets, and the public interest did not warrant her removal from society. She had no criminal background and absolutely no indication of any prior sexual misconduct, and he ordered an evaluation that indicated she had no sexual interest in children and was not a danger. So that's the government interest in her. On the other side of the ledger, she's a resident of a family shelter at the time with her husband and infant child. Defense counsel raised the issue of the likelihood of her being evicted from that housing upon receipt of the initial classification by SORB, from SORB at the shelter. But I would also point out that under the statute, homeless shelters have an obligation to cooperate with SORB and to verify the address of offenders living there. And so within 2 days, she would have had to register. SORB could have contacted the homeless shelter, and they would have found out right away about her convictions, and she would be likely to be evicted. And homeless offenders have to register every 30 days. If they don't register, don't verify registration, if they don't indicate any movement 10 days ahead of time, they're subject to, as the court have described, really draconian punishments. 6-month mandatory sentences, $1,000 fine a homeless person isn't going to be able to pay, and a second subsequent 5-year mandatory sentence. So as this court so eloquently stated in Doe 380316, the consequences are very harsh. So balancing what the judge had to say about the defendant with the consequences to her of having to register certainly argues that she has a right to show that she is not a danger.
She has a right to show because of, is a due process, right?
Yes.
But so to go back to Chief Justice Gantz's question, why, she would have that right there, but if there were a mandatory sentence of 10 years for statutory rape, what would you be here under the 8th Amendment? What would you be doing?
Oh, well, so I don't think it's unfair for the legislature to have established a procedure for the sentencing judges to consider when they've decided that probation is appropriate.
She was probably just a few years away from the minimum mandatory, correct? Because of the age discrepancies?
Possibly. I didn't, she
right.
was 22 and I think 14 or 15, I'm not sure.
Right, but it's a 10-year age discrepancy. Right?
These are very, very compelling issues, but so under 178EE, someone can be sentenced to incarceration, but the Commonwealth has to bring forward a motion to have them given this opportunity.
But am I correct that Doe 8725, the reason for the individualized hearing was because of the retroactivity, because the conviction had been so long ago, wasn't that?
Well, that retroactivity was mentioned and that was brought up there, but in Doe versus Police Commissioner, the court indicated that, well, the court said retroactive application wasn't an issue there, and cited the same balancing of opposing considerations. Said the same test is generally required whenever the government deprives an individual of a constitutionally protected liberty or property interest, which certainly is present here, liberty, privacy, and property. As we've discussed, the possibility of incarceration if any registration requirements are violated, her housing in a shelter, likelihood of becoming homeless, as this court has indicated, affects many sex offenders. So I do appreciate the question. In this particular case, where she was given probation, she satisfied the number one criterion for that section. And the legislature did create something of a system for sentencing judges to excuse people from registration requirements. If no more questions on that issue, I can move on to the trial itself.
Yes, please.
So it's clear from the trial record that the jury had a very hard time with the case. The jury was out for quite a long time, 3 times, I think 3 times the amount of time it took to actually hear the evidence in the case, had to get a Tui Rodriguez charge, and finally was sort of moved into action by a question from the judge. The judge's findings indicate why that could have been the case. And I would say that under those circumstances, the closing argument by the prosecutor, along with police opinion that was included in the otherwise redacted video played for the jury, made the difference in the case, and really cannot be said to have not very likely affected the outcome. The prosecutor did a number of improper actions, including vouching for the credibility of the 2 immunized witnesses. The only evidence in the case came from 2 immunized witnesses who were unwilling otherwise to testify. And that was because the judge was appointed counsel to them because he was concerned about evidence that the defendant was drunk, that the young men carried her into the woods, that they had misled her as to where they wanted to go, and that sort of thing. So that was the only immunized witness testimony in the case, and the prosecutor vouched for that. He also argued about
testimony as to what had happened?
Yes. Yes, it was 1 complainant out of 3 who came to court, and then a witness, a younger witness.
There were 3 young men, though, involved in the
There were 3
incident.
young men, and only one of these young men came to court.
Only one?
Yes. The second immunized witness was a friend who was with them.
So how many testified?
2 people testified, 1 complainant and 1 witness, and the police
And
officer.
both were immunized?
Yes.
Was AC one of the ones who testified?
Yes, and he was a witness.
Right, so he was the younger.
Yes, and that's just to, I guess, flip back a little bit. The police were very, very voluble about how much they believed AC, and in the police interview. And part of what was a problem in terms of playing for the jury, it was played for the jury, and the jury had access to the video, and they played it over and over and over again, according to the post-trial motion of the defense. They vouched for his credibility in the videotape. In addition, they also gave their opinion that she was guilty of statutory or forcible rape. That was one problem, but so that in conjunction with the closing argument where actually the prosecutor gave his opinions of the purpose for the statute, really evidence, he gave testimony that was not evidence in the case.
Were objections raised to the?
Yes, there were objections
And did the judge
raised.
give curative instructions?
Inadequate, limited and inadequate curative instructions were given. Very limited, and only to some of the objections that were raised. He al-
Was there an objection to the police opinion in the statement?
Yes, yes. The record really is very well done. And I just want to issue mention the motion to suppress, which also really should have been allowed. I just want to give any other questions I would love to have a chance to answer before the red light. Thank you.
Okay, thank you.
Good morning, Your Honors. Stacey Gothier on behalf of the District Attorney's Office, Plymouth County. I guess I will start with the issue with regard to the SORB. I would argue that the defendant's due process rights were not violated by the judge's failure to relieve her of her obligation to register as a sex offender, where the judge had no such discretion because she was convicted of a sex offense involving a child, and the state has a compelling interest in protecting children from sexual abuse.
Do we take
Well, I
into
think
account?
she's being more
I'm
specific.
sorry.
Go ahead. Go ahead,
Justice
Justice
Link,
Hyman.
I'll defer to you.
No, please.
Okay. As I understand it, she did say that the judge made a mistake, but she went on to say that the statute as applied to her, I think that's the argument that's being made, violated her right to due process. So could you address that?
Yes, Your Honor. Under Commonwealth versus Dalton, this court in 2014 ruled that the judge has no...
I know. Dalton is the statutory interpretation issue. What I'm looking for is the Commonwealth's response to the constitutional argument.
Well, there was no actual evidence at the hearing that, first of all, I would say that it wasn't objected to that the judge didn't relieve her of the obligation. So I would suggest that this would be at a substantial risk analysis. However, there was the defense attorney only testified that she had been living in a homeless shelter, and he was not aware of any homeless shelters that accepted people who were registered as sex offenders. There was no actual evidence that there was any sex offender disqualification from a specific homeless shelter that she was living in.
Do you realistically think there are any homeless shelters that allow sex offenders?
I don't know, Your Honor.
Would it matter if it turned out that there would be no homeless shelters that would take her? In your view, would that be of any consequence?
Well, at this point, she hasn't even been classified by SORB.
Okay, but try my question.
sorry.
If it turns out that the consequences of being found to be that registration as a sex offender would have all the consequences that Ms. Dahlberg describes, would it matter in terms of your argument? Is it your view that that's all irrelevant?
Well, if there was specific, well, yes, she would have a better argument if I would suggest if she specifically came in.
Is it your view that if the parade of horribles she describes were true, would it have any consequence legally in your view?
Well, it would affect her ability of where to live. So at that point, her due process rights would be violated. However, there was no...
So tell me how that would be. So if it turns out that it would mean that she has no place to live, that would trigger a due process?
That has been held to trigger a due process. I believe that was Doe versus the police commissioner, where he had been forced to move out of a nursing home that he was living in. But here, she can get her due process rights through the SORB. I would suggest it's not...
How is that? Because SORB regulations say that they can't waive it either. They're in the same position as a judge. So where is her due process protection under SORB?
Well, here, the legislature has specifically made the law that because there's a child involved in this issue, that the judge has no discretion.
I get that.
So SORB, but they have given that discretion, Your Honor, to SORB after a 10-year period.
Okay.
So I would suggest that's not
forget the 10
right
years,
at this
okay?
point.
Right, it isn't. So why is it that you say that she has protections under SORB when she has to register, there's no way to waive that condition, and she can't go back for 10 years?
Because SORB is the board that has expertise. SORB was the board that was created by the legislature and that has expertise in dealing with people who have been convicted of sex offenses.
So where does she get the individualized examination that the court said was required in Doe 1211?
She would get that in front of the SORB board, which I understand she can't get for 10 years. However, that would be an issue
So
of
the
due
10
process
years
rights
doesn't
before
bother you at
SORB.
all?
I'm sorry, what was that?
The 10 years, that doesn't bother you?
I would suggest that it could be an issue, but it's not ripe at this point. So she's not able to address it at this point. It's not ripe until she actually is before the SORB board and SORB classifies her. The legislature has specifically given the SORB the availability of allowing her to not register after 10 years. So when her case is actually in front of the SORB board, the SORB, which is the body with experience in this, they can make the determination after 10 years. That's where she gets her due process and her individualized hearing.
You know, you started by, I thought, going down the Eldridge Matthews factors by talking about the Commonwealth's interests here. Do we not, is that what you're doing? Are you taking into account those factors for due process analysis? And
I
if
did not take those into account in my brief,
Then why are we
Your Honor.
talking about the Commonwealth's interests?
I'm sorry, I don't recall when I talked about the Commonwealth's interests.
You talked about the Commonwealth's interest in having a registration process for somebody who has been involved in connection with a child assault.
Well, the legislature created that.
So you're just saying that that's what justifies the statutory interpretation?
Yes, I'm not saying that it
Not
was the
talking
Commonwealth.
about the due process the due process issue.
Correct.
Uh-huh.
I'm sorry, if there's no further questions on this, then I'll move on to issue number 1, which was that the motion to suppress was properly denied, where the Commonwealth met its burden of showing that the statements that she made were voluntary, and in the totality of the circumstances, the police tactics were not so deceptive as to render them involuntary.
There's some questions concerning losing her child, and I understand that there was a different custody situation than there has been in other cases where the person being interrogated actually had custody at the time, but the police did bring up the issue of access to her children.
Your Honor, I believe there was about 5 or 6 references to the defendant's children in the interview, and only one of them the police brought up. The first 4 times, it was the defendant who brought up the issue of her children. The first time was about 17 pages into the interview, where she said, you know, I have children. At that point, the police made no response. She then told the police that AC's mom, at one point, I guess, had confronted her and was talking about her children. And then she says, I have children, I'm trying to protect myself, to which one of the detectives merely responded, you're not protecting yourself right now. And then one of the officers did say, if what's happening is you're afraid to tell us because you're never going to get your kids back, is that what you're afraid of? Okay, I understand that. You're not doing yourself any good by lying to us. They certainly weren't making any threats that her children were going to be taken away, unlike the Monson case, or I think it was, the Monroe case that my sister had cited.
But why isn't this case stronger in a way? Yeah, the police let it go a couple times, and they see that this is a palpable concern, and then with the last question, they sort of seize on that palpable concern and say you're not helping yourself relative to your children, which you keep, parenthetically, which she keeps on bringing up.
Well, at one point, they never suggested that her children were going to be taken away improperly, as what happened in the other case, where the detectives falsely told the defendant that if his girlfriend's child was taken away, it would be his fault. They never even told her anything close to that. And at one point, towards the end of the interview, the defendant had stated, after she made the admission, she stated, I'm going to lose my kids. And the detective said, not necessarily. So I would suggest that this behavior is not like the aggressive type of behavior that was cited to in my sister's brief. She was the one who kept bringing them up. They they did question her on that at the end, but then when she finally said, I'm going to lose my kids, they said not necessarily. So that's, I would suggest, that's nothing like saying, you know, you're going to be the reason your girlfriend loses her kids.
If you could turn to the closing argument, specifically the time period that elapsed between the first set of incidents of oral sex and the second set of incidents of vaginal sex.
Yes, Your Honor.
Do you agree with the defense lawyer that the evidence supported a finding that it was no more than 30 minutes?
Yes, however, what the Commonwealth actually said in their brief was, in some period elapsed between episode number 1 and episode number 2, be it 45 minutes, an hour, or an hour and a half. So I would suggest by saying in some period elapsed, he was indicating that he wasn't sure, or he wasn't giving like the exact time period.
Doesn't that phrase suggest he's giving the shorter and long, I mean, he's giving the range of possibilities? Which,
Yes.
Which is
Yes.
all of them being longer than 30 minutes.
Right, so what I'm saying is he's, by qualifying it by saying in some period elapsed, I would suggest that he was indicating that he wasn't sure how much time elapsed. However, if it was error, if it
was there any evidence that it was as long as an hour and a half?
I don't recall that there was, Your Honor. I don't recall that there was.
Jury found her not guilty with regard to the first set of incidents,
They found her, right, correct, they found her not guilty of 3 counts.
and we don't, of course, know why, but an inference might be because they found her too intoxicated to be a knowing participant in that.
That could be.
So the passage of time matters because they did find her guilty of the second set of incidences. Was there an objection to that with regard to the time period?
There was not an objection to the time period, Your Honor. No, there was objections to him saying that 3 boys testified when only 2. There was some burden shifting, the sympathy and the oath, the reason for the statute, and then the hypo that he gave. There was no objection to the misstatement of the time that I'm aware of.
And why does that not matter? I guess it would be a substantial miscarriage standard.
I would
Substantial risk
suggest
standard.
that in the whole of the closing argument, as well as the judge's instructions to the jury, that it was a minor misstatement. The judge also told the jurors in his instructions that closing arguments are not evidence, and that that they're the ones who determine the facts. It's their memory that controls. So I would suggest that if it was a misstatement, then the judge's instruction cured it.
Well, usually that would be a minor misstatement, but if you look at the verdict and the evidence in this case, you wonder if it's really a minor misstatement, for the reasons that Chief Justice Gantz just mentioned. Sometimes what's minor in some case can be major in another case.
Correct, that's correct. Well, I would suggest then that if there was an error, that the judge's instruction, when he told the jury that it was their memory that controls, that would cure an error.
Well, it doesn't cure all errors, as Silva Santiago demonstrated.
No, that's correct, Your Honor.
Okay,
Thank you. I'll rest on my brief if there's no further questions.
thank you.